Well, so thank you all for this opportunity, and I'll launch right into the subject. Let's see if we can get this to work. No. Here goes. Right. Just a very brief recall of what the objectives were of as proposed by the Commission. And as you can see, we have, broadly speaking, these 5 overall objectives with the reform. So simpler, more flexible procedures, strategic use. What we mean by that is that there is a very strong tendency to try to use public procurement to further other policy objectives. So, for instance, to promote innovation or to promote environmentally sound developments or other societal goals and objectives. And the big question that we have until now is exactly how do you do that without compromising also the underlying objectives of public procurement legislation, which is, after all, an internal market legislation, so aimed at free movement of goods, service, and so forth. And that the objective here of trying to make clear exactly how, to what extent, and at what stages of the procedure you can integrate strategic objectives in public procurement, that is also very much an issue here. Very much, very important, as was said earlier, is of course the whole idea of trying to improve the access for, in particular, small and medium-sized enterprises, and to try to improve the ratio of actual cross-border award of contracts to open up the opportunities. Also at the same time, we have the objectives of trying to ensure that the procedures are as safe as possible from, for instance, phenomena like corruption, conflict of interest, and that kind of possible problems that can completely bias, of course, the outcome of procurement procedures and render, in fact, the whole competition an illusion, in fact. And tied in to some extent to that is also the fact that we do see quite many problems in terms of meeting the legal requirements currently, and many of those we have to say are not due to some determination to go out and break the rules. Very often the issue is tied down to the fact that you have quite a number of contracting authorities who might do very few procurements that are subject to the public procurement rules, and therefore there might be a role for strengthening the level of professionality in those involved in public procurement rules. But if we just take 2 minutes or even half a minute to consider these 5 objectives, I mean, taken individually, you know what you ought to do to favor that particular one. But I think you can see that trying to reconcile all of these 5 will mean that we will have to make a number of compromises, of course, and therefore, if people are understanding simplification as, for instance, a reduction in the number of provisions, well, that won't sit with, for instance, the objective of clarifying how you can use procurement in strategic procurement, or if we're talking about giving as much flexibility as possible to local authorities or contracting authorities in general, well, that will, of course, at times expose us to a risk of having problems in terms of sound procurement. So please bear in mind that already these 5 objectives do render some compromises necessary. And another general point I would like to make is that we should also bear in mind that these provisions will eventually have to be capable of being applied in 27, soon 28 different member states with very different administrative traditions, with very different legal systems. And I mentioned that because, for instance, in my native country, Denmark, there is, of course, a tendency to see, okay, we have certain traditions, we can handle flexibility without that giving rise to, normally at least, corruption or that kind of stuff. So, okay, why do we need all these additional safeguards? But things might be different in other member states. So there are certainly a number of cases where there is a genuine need for certain safeguards, certain explicit provisions, to be able to cater for the situation in all member states, which, strictly speaking, might not be necessary if we were legislating just for 1, 2, or 3 specific member states. So that is another general point. But enough about that. Just to recall what the scope is of these proposals. First of all, and that's, I think, important to stress, we need to remember that we have to move within the framework set by the government procurement agreement in the WTO. Because, of course, the union as such has a series of legal obligations, and we need to ensure that we don't breach those, or be aware at the very least that if we do go out and breach the legal obligations, well, then we are bound to be faced with requests for compensation from our partners. So that is something very much that needs to be in our minds when conducting the negotiations. We're talking about basically proposals to replace the 2 current directives, so the Classic Directive 2004-18 and the Utilities 2004-17. We're not talking about modifications to the Directive on Defence Procurement or in terms of the Remedies Directive, with one little exception, namely, of course, that the other proposal, the proposal on concessions, will extend the scope of the Remedies Directive also to cover the procedures for the award of concessions, be that in the classic sector or in the utilities sector. But that change is simply to the scope of the Remedies Directive, not at all to the procedures provided for by the Remedies Directive. Again, in terms of for coverage, and I'll be brief as much of this has already been covered, but just to recall the main steps, we had the proposals by the Commission in December 2011. We had Council adopting a general approach, which is, if you want, a sort of formal political agreement on a given text. And that was adopted for all 3 proposals, so Classic Directive, Utilities and Concessions at the same time. Parliament adopted in IMCO. IMCO is the abbreviation normally used for the Internal Market and Consumer Affairs Committee, which is the leading committee, as was explained earlier. Adopted its reports on all 3 proposals on the 18th of December for the Classic Directive, and on the 24th of January this year on the 2 other ones. And then, as Ms. Evans was saying earlier, we have started trilogues in February with the technical preparatory meetings and the formal trilogues in March, and they are very much ongoing. As was said earlier, this Tuesday we're going to tackle some of the more substantive issues and the more controversial issues around, as was said, award criteria, around the duty to respect social legislation and so forth. But I'll come to that in a moment. So just to give you a very quick outline of where we stand, The main amendments in Council's general approach compared to the Commission's original proposal, which, by the way, I won't go into detail about because, well, it's more than a year old and things have developed so fast that it really it's not all that relevant. Just a general remark that actually there are, of course, big differences on a number of issues, but the basic substance is still there. So the Commission's proposals are still the general approach to most things. What we have is a big difference in terms of the so-called light regime. What I mean by that is simply that the current directives operate with a series of priority services, those which are listed in Part A of Annex 2, to which the directive is applicable in full. And then you have a residual category, basically all other services, where you just have currently two obligations under the detailed provisions of the directive, namely the obligation of informing the Commission once the contract has actually been awarded, and the obligation to respect the provisions on technical specifications. But I stress that those are the obligations under the detailed provisions of the directive, simply because there is jurisprudence to say that there is an obligation to ensure adequate transparency, adequate publicity under the treaty. And that is, of course, quite an issue because exactly what is adequate publicity? And there is quite some legal uncertainty on this issue. So what was proposed by the Commission and seems to be fairly acceptable to both of the two other institutions is that we move away from that system. We have as a starting point the fact that the directives will apply to all services, no matter what they are, with the exception of a certain certain categories of services which this time round would be listed exhaustively in the directive. And with the difference that, okay, as of a threshold of 750,000, which is higher than they originally proposed, but still, there will be an obligation in any case to ensure publication before you actually launch the procedure. So there will be full transparency at the EU level, and then a provision simply saying that you have to have provisions at the national level on what procedures to use for this, but with very, very light requirements. What Council did was to add a series of categories to the list of services. We had originally proposed simply to cover social service and the educational services, and Council wants to add in particular a series of legal services, some administrative services, restaurant catering services, that kind of services. And of course, when you look at the list as it appears in Council's text, you get the impression that okay, it's quite long. But the point is that when you compare it to what is the current situation, we shouldn't forget that we have very large categories, entire categories of services which are transferred in any case from the current B list to the full, complete regime of the directive. Where we have another big issue, a big difference in Council is the requirement for documentation in the procedure of qualifying on undertakings. Because the Commission proposed a so-called procurement passport, which Council has rejected because indeed, if adopted as proposed by the Commission, Member States would have been obliged to appoint an authority responsible for issuing the passport, and there were a whole range of discussions about the administrative burden, the additional the added value about that. So in the end, what Council did was to scrap the procurement passport, but on the other hand, compensate that in quite an efficient manner, I must say, by a requirement for contracting authorities that whenever there are national databases holding the information, well then contracting authorities must search in those databases instead of asking the economic operator to deliver the evidence, the certificates, attestations, so forth. And of course, at first sight, that might seem quite an undertaking for the authorities. How do they know where there are databases and so forth? That is, of course, catered for in the sense that the self-declaration which economic operators will have to deliver at the beginning must state where there is information, what databases, exactly give consent to access the information, so forth. So the task is certainly not unsurmountable for contracting authorities, and it will render life much easier for economic operators. On governance, well, of course, there was the big issue of the single oversight body that was mentioned before. And I guess although we don't have yet a formal commission position on it, but I think I'm not revealing any big secret in saying, well, that particular idea is dead, because it has been rejected by a very, very large majority, both in Parliament as well as in Council. So I think it's a pretty fair guess to say that particular idea is not going to be part of the final outcome. And as was said earlier also, of course, we have a big issue on the whole aspect of public cooperation, and there what Council proposes is to increase the amount of work contracting authorities may do outside of the scope of the corporation. So, in fact, on the free market, from 10% to 20%. And of course, just as a remark on that issue, that of course, yes, indeed, it is very important that we have sufficient flexibility in public cooperation. That is, of course, a very legitimate concern. What we shouldn't forget, though, is that it is also at times a reservation of contracts, a reservation of work. So whatever is carried out in the context of public cooperation, in particular if it's carried out on a simple basis of one authority providing the service, the other one paying that, well, that is, of course, contracts which private economic operators are deprived of. So we need to strike a right balance there between legitimate cooperation on the one hand, the interest also of the internal market on the other hand. And then a very big difference is the issue of where, at what time we need to have a transposition of the directive, and in particular, as of when the use of electronic means of communication should become obligatory. So these were the main differences in Council's general approach. And if I now take IMCO's report, well, we have a whole range of different amendments that I've tried to summarize on the turn of localism, because what we are talking about is for instance an award criteria which as such would simply be cost effectiveness of short distance award, which I think doesn't require all that much imagination to see could very quickly lead to simply regional preferences with all the problems that poses in terms of primary law indeed. What it covers are factors like wanting, because it is true, as Miss Evans said before, that we are introducing a series of provisions on the use of life cycle costing as a means of or as one factor that can be taken into account when awarding the contracts. And by the way, I would like at that point to perhaps well, so there might be some misunderstandings at times about exactly what it is the current legislation says. And I stress that is what the legislation says. What practice says is something else. But what the legislation says is actually that there is a completely free choice between the lowest price only in the current directives and the economically most advantageous tenders. So it is, I'm sorry to say it so bluntly, but it's simply not true that the directives impose use of lowest price only as an award criteria. That many authorities do so in practice, that's a different issue, but the legislation does not in any way impose it. The proposal as it stands would actually go one step further, because in Council's and the Commission's text, we move away from the concept of the lowest price only to a concept of the lowest cost. And the reason why we do that is not simply an issue of terminology, but because we have said explicitly that even if you don't want to look at other aspects, you can still judge the cost on the basis at that point also of life cycle considerations. So you're not obliged under any circumstances to base your, even if you don't want to take the more complex issues as in environmental qualities and so forth, even in those cases, you're not obliged to take only the acquisition price as your basis, but you can add in the price of using the goods or services or works in question, the cost of recycling it eventually, and so forth. So that is certainly possible. But okay, that was set aside. In the definition of life cycle costing, Parliament proposes also to use criteria linked social external costs. Well, one example that immediately springs to the mind would be the following: that you have a local authority who says, okay, if I award the contract to a company from another member state, well, what will happen will be that the workers at the local incumbent will no longer have an employment. I, as a contracting authority, will have to pay unemployment benefit. I might have to have additional expenses for additional training for these. So social external costs are much bigger. Therefore, I think the picture is clear. And of course, it might be a valid criterion if we could count on the responsible for procurement of having a very high degree of altruism, to say, okay, the social cost in my municipality will be offset by the social advantages obtained by another municipality somewhere, but I'm not entirely sure that there is that level of altruism. So that's one of the reasons why we have some problems with this particular criterion. What we have is also, and this is very much also shows you a bit the tension between simplification, flexibility, clarification of the rules, is on the whole issue of modification of contracts, because well, currently we don't have any provisions at all in the directive. What we do have is some jurisprudence, which is certainly not easy to apply on practical cases. So what the Commission has proposed is essentially to, on the one hand, to codify jurisprudence on a certain number of issues, and to simplify, to give, in fact, additional flexibility to contracting authorities in the sense of introducing a a de minimis rule. So to have a provisions that says explicitly that under certain conditions, what we are talking about here are situations where the value of the modification is, as proposed by Council, not above 10% for supplies and service contracts and 15% for works contracts, and that little word is quite important, as we're going to see, and does not in any case go above the applicable threshold. In those cases, contracting authorities can modify the directive without having to make any further examination. They don't have to make an assessment. Are these modifications, are they substantial, are they non-substantial? They simply have these numerical criterion. If you're below, well, then that's it. You can modify the contract, full stop. And on that issue, what Parliament wants to do basically is to render these two criterion, so the percentage and the cap set by the threshold, alternatives, which would in fact pose quite some problems, because what it would mean would also be to say that we are introducing the possibility, in fact, of awarding a contract without a call for competition for contracts above the threshold in cases which are not allowed for under the GPA. So we do have quite some issue with that one. There are Parliament wants to introduce additional exclusions on danger prevention, which I'm not entirely sure what that means. It's coupled probably to issues around civil defense, disaster prevention, rescue services, that kind of thing. But danger prevention, of course, as it stands, is something entirely too broad, in particular in a complete exclusion from the scope of the directives. And then an old friend, which we had also in 2004, a complete exclusion for all contracts where you have a fixed price. So, for instance, school books in some member states. This time around, you have certain liberal provisions where price have been established by legally binding tariffs, and of course. Well, certainly for us in the Commission, that does pose quite a problem. Because apart from everything else, again, we have a problem of compatibility with the GPA. But of course, I shouldn't paint too black a picture either of what Parliament wants, and I may. Indirectly have given that impression by omitting a very important point in this list, but that happens, namely the fact that on governance issues, Parliament is very much in line with the Commission, not on the single oversight body, but on the need to have some reporting, some ways of actually following what is the effect of the directives once adopted. How are they being monitored? What is the actual effect in terms of, say, small and medium-sized enterprises? Do they have an additional access and so forth? And another aspect where Parliament is indeed much more ambitious than is Council is in terms of the deadlines for e-procurement. So it is not a black and white picture. That was simply what I'd like to stress. But we do have an additional very big issue, namely that Parliament has first of all voted an amendment to insert the current provisions of the utilities, Article 58-59, which gives some, let's say, some community preference Uh, they first of all inserted those in the utilities, and they have inserted that also in the classic directive. And this leads me then to where we stand in terms of main problems. As I think you will have understood, and I'll try to speak to speed things a bit up. We will have big issues around the use of the most economically advantageous tender as opposed to allowing use of the lowest cost, at least in some types of procurements. The whole issue around the localisms. And the big issue we have is on the obligation to ensure compliance with social, environmental, and labor law. Here the issues are a bit, I won't say sneaky, but the underlying issue is really whether we need to stay within the boundaries that have been set by the Posting of Workers Directive and the jurisprudence attaching to that one, or whether the legislator could, in this particular area, set other provisions going beyond what is possible. So in clear, in the Posting of Workers Directive, you can of course require the provisions of collective agreement in particular are observed, but provided that these have been declared universally applicable. There are some provisions on equivalent measures, but that is the basic idea. Parliament, or perhaps should I say some parts of Parliament, are very keen to have the possibility to impose observance of all collective agreements, whether or not they're universally applicable. And that is of course going to be a fairly big issue between Council and Parliament and us for that matter also. Also because it's not entirely clear from the amendments that the Parliament has posed that if you analyse the text, it is actually way beyond what is possible under the Posting of Workers Directives. But apparently some of the parties who've ended up supporting that in Parliament were not aware of that. They were under the impression that the compromise fund was well within the boundaries set by the Posting of Workers. So there is some tension there. Just going to some of the bigger issues again, as was said, we need to very much to focus on the exclusions, public, and the transposition deadlines. That those are going to be fairly big issues, and there is certainly the potential that the issue on reciprocity. It does have the potential of blocking the whole process, because it is one that is so ideological, both in Parliament as well as in Council, that in particular in Council, we actually have blocking minorities for anything that goes beyond restoring status quo. So in clear, Council has accepted with enormous difficulties to reinsert the provisions of the current directive in the utilities only, but we are sure that it has the potential to block the whole thing if we have to try to insert it in the classic directive also. 2 words on the utilities. We have very few specific issues. By and large, we have the same issues as for the classic. We do have some additional exclusions like an exclusion for commercially strategic contracts. And the example, which was quite interesting, that was given by the rapporteur, was that if a postal operator buys, say, lorries, that is a commercially strategic procurement. So having a complete exclusion for that kind of procurement is somewhat problematic, to say the least. But I guess just I promise it's 1 minute. Exactly what the aims, the conclusions we're drawing so far is that yes, we do have some pretty tough nuts to crack, but I think we can arrive at it. So the aim is still to finalize and adopt the directives in first reading. In terms of timing, what we hope to achieve is at least a political agreement on the substance under Irish presidency, even if then the formalization in a plenary of Parliament might take place in September. But the objective is very much that one, to have the adoption in first reading still this year. Of course, remains to be seen if it's feasible, but we are still, I think, reasonably optimistic on it. So, thank you.